I wanted to mention two matters which are appearing at page number 445, item number 140.
140.
140 and 152 item number for upgradation.
Item number 140 and 152.
152.
Updated.
And also, madam, there is another stay application for insurance matters. I'm good.
That I was mentioning, item 161. It's at page 447 of my losses. Page 447,
167.
161. I'm sorry, 161,
Yes.
162, 163, 164,
164.
and we're at page 449. Item 179.
179.
This for upgradation
Okay. 5 matters.
on Monday.
Yes. Monday.
Well, may be permitted to mention, my lord, one matter. Well, it is my appeal, national appeal of the National Insurance Company Limited. My lord, it is a very simple matter. Only pay and recover I have paid.
Who is appearing for the insurance company?
I am appearing for the insurance company. He is appearing for the claimant, my lord.
Okay. Whether it is listed
It has not yet been listed, my lord.
for hearing?
Hearing not to be mentioned anything. Hearing for
No.
hearing.
Whether it is the paper books are ready?
No, paper books is not required, my lord. Only point is this pay and recover.
Okay. Then what is the stage? You just file the appeal.
No, my lord. I have filed the appeal in the 2 years ago.
Okay. Okay.
Insurance
To be
claimant has
mentioned.
appeared. To be mentioned, my lord. To be mentioned.
Yes.
Malad, may I be permitted to mention one matter, Malad? I mentioned this yesterday, Malad. This is urgent stage because, Malad, an execution proceeding has been initiated and, Malad, there is an order of attachment of the bank account. But unfortunately, it is not listed today. But I have given to understand the file is in court, Malad. I am praying may it be taken up any time today, Malad, subject to your lordship's convenience.
Today, since 2, I have some determination. Other determination.
Try to do at 1 or 1 past 10, Malad.
It has to be listed. Otherwise,
After this, your lordship can take it up or a supplementary list may be published.
no, it has to be listed. Otherwise,
Then
the supplementary list would be appear at 2 p.m. 2 p.m. I have other determination. Otherwise, I will take
Monday,
it.
some precedent-
Yes, Monday it can be done.
Some precedent.
Lord, may I? Monday, if it is listed, you mention it. I will take up.
Lord, may I make a request here? Lord, open this item number 166.
166.
I think 166. Already exhibition things have started. But I'm praying, Lord, due to my personal problem next week, I cannot come. If your lordships kindly take it up today for stay. So to usual undertaking that we have to deposit the entire amount.
166.
Yes. Anytime as your losses today. I have some problem in eye and might be operation the next week. So
Very well. Keep it 166. Okay. I will take up the matter.
My lord, may I be permitted to mention 5 cases for insurance company? This is advocate on record, Mr. Afroz Alam. He has sent all the list, prepare this, all this.
For application or hearing?
Application.
Only
Only
for
all
application.
of stay application.
Okay. Application for stay.
May I have your lordship please to mention this matter as application for listing?
Lordship, mention the matter for stay application.
Okay.
There is certain urgency if the matter may be taken up.
Let it be list first.
Okay.
Number
Achha,
60 and 94 of today's list, my lord. And I am praying for a little bit upgradation. My other side is my here, Mr. Pahari is appearing for the insurance company. This is with regard paper books are ready in both this matter. Does it kindly give some upgradation on Tuesday or Wednesday, any day convenient to your lordship?
60 and
94, my lord. And
60 is the hearing.
Yes, my lord. It's a hearing paper book is ready, my lord. It's
60.
only yes, my lord. 60 and 94 both.
94.
4.
94 is for applications.
No, it's had wrongly been appearing. It is a hearing, my lord. But there is an application for condonation of delay is also there, but There's a delay of 31 days. I have filed the application. I have served the Miss Sucharita Pal is appearing on behalf of the insurance company. Would
You inform him.
I will inform you. Your lordship, kindly give some precedence on Tuesday or Wednesday, any day convenient to your lordship.
Item number 60
And
and
94.
94. Upgrade code for hearing both the matters. Hearing.
Tuesday or Wednesday.
Wednesday.
I'm great.
That's the one matter left.
Wednesday means it would be 10th.
10th month. Okay.
Yes.
One hearing matter left for inclusion.
Okay.
Lordship, another hearing matter for inclusion in the.
For hearing,
Yes, my lord.
you are appearing
I'm for the petitioner.
for the petitioner.
Yes, my lord.
Appellant. no.
Appellant, yes, my lord.
Appellant.
Petitioners, my lord.
Claimant.
Appellants, claimants.
Appellant's claimant.
Yes, my lord.
Okay. Ready matters.
Yes, my lord, the pleadings is complete. My
Paper
lord,
books.
it's all submitted, my lord. Actually,
Whether paper books are ready or not.
my lord, it's ready. My lord had already directed that the matter to be listed for hearing on the 4th of December, but then it was then removed from the list. So I'm praying for the matter to be listed. Obliged, my lord.
Call the list. This is criminal appeal C59 of 1989 in the matter of Dilip Kumar Rana. Considering the entire aspect and considering the entire materials on record, it appears to me that the learned special judge has misguided himself in passing the impugned judgment. The learned special judge, in one hand, has held that the prosecution could not produce the relevant chemical examination report, as well as the prosecution failed to prove that the shop was closed for an ulterior motive. On the other hand, the observation of a learned special judge against the finding of the present appellant to be guilty for violation of the relevant paras is erroneous. The case of the prosecution has the reasonable doubt. The prosecution has failed to bring home the charge against the present appellant beyond reasonable doubt. Accordingly, I find justification to entertain the instant criminal appeal. Criminal appeal is allowed. The order of conviction passed by the learned special judge against the present appellant is hereby set aside. Appellant is hereby acquitted from this case. They are disposed of. Next.
For the appellant.
Seventeen two.
Yes, sir. My lord.
Who is appearing on behalf of the railway?
Sir, S.K. Mishra.
Where is it?
See online. There is an online list.
Okay. Then you start.
Sir, my lord, this was for 17-2 delay, and there is a delay of 5.5 years. The case was the incident occurred at 9/7/2013, and the same was filed on 10/1/2020. And in the meantime, as not only that the state has been changed, the incident occurred at Patna, and the applicant is from Malda, so their base language is Bengali. So going over there, and the language is totally different. People over there, the GRPs over there are of Hindi. So getting over there, getting all the certified copies is a bit difficult. Was a bit difficult point. And thereafter, the only RCT lies over at West Bengal, is at Kolkata. There is no other subdivisional court where they can go or they can seek the help for railway matters.
Incident happened on
9/7/2013. Thereafter, they had contacted
9/7/2013.
30. And thereafter, they had contracted one lawyer come or somebody else has came to their doors to seek help, and they had given some of their documents to them. But they had assured that they would be filing the same at the court. But they had given no details about the court where it would be filed or anything. And they came from very rustic village, and they had no knowledge about such things. Thereafter, days passed on, and when they tried to contact the same, there was no other person to help them or nothing they could contact to that person. And thereafter, they were and in RCT, no, like
When the application was preferred, claim application?
10/1/2020.
Along with the application under section 17(2).
Along with this application 17(2). And to file such claim at RCT, we need all the documents. At first, we have to collect all the documents. And there are two specific points. We have to take the Surathal report as well as a final report. Without this two, nobody can or no one can file the case before RCT. So to get that thing, one has to first do RTI. They have to wait for RTI, or they have to personally go to the concerned GRP, and by challan formation, they have to get all those documents. In this case, several RTI were sent to the concerned department, but no reply from their side. Just that this is a provision and or this has been exempted. So the applicant, they were very poor person. So they personally went to Patna to the same GRP, and by doing all those challan things, they had received all the copies except the final report. And all these things were in Hindi. So thereafter,
When you received the documents from the Patna?
Patna. Receiving date is not been mentioned, but it like we had applied in the year 2014. Like the previous person who took all these things, they applied at 14, and might be they have received in the 8th month of 14. From collecting those things from that person who has taken all these things from them took a long time. They had then again came to the RCT to find out what the procedure or what is the status of the case. Thereafter, they knew from that RCT that nobody has filed their case. And thereafter, they contacted the same advocate, Manas Datta Chaudhary, to file. And thereafter, they again hold the process at beginning. And such an inordinate delay has occurred. And if you go by the merit of the case, already they have submitted the DRM report, where in the final report they have admitted the fact that the person has fallen down, and as well as in the Ratia Rail Thana, where the incident occurred, and has investigated the case, that police also has admitted that this case that he गिर के like train से गिर के इनकी मृत्यु हुई है. And in the Surathal and every report they have said this incident occurred due to train accident. And about ticket, nothing was been discovered with him. No, like neither the bag, neither anything has been discovered with him. So the ticket was lost. Thereafter, one PNR inquiry was made by the parents after the accident has occurred. From there, one list came out of the ticket. So that has been filed at the time of filing.
So you received the documents from the Patna in the year 2014.
Yeah, yes, sir.
Then why you file in the year 2019?
Because the person who took the documents from them or the signatures or everything, that person did not file, and thereafter they contracted the second advocate in the year 2000, at the end of 2019 or 18 December. Thereafter, he had again to go through all these procedures. They had to contract that person to collect all the relevant documents which he had collected during this whole tenure.
No, you have not stated such in your application.
That's stated.
You have not stated.
In the short, in the point number 4, I stated that in 8 December 2019, they had collected they had contracted Manas Datta Chaudhary. And in the 17-2 application, all these things were mentioned.
Yes, I am paging the 17-2 application. Nothing has been mentioned. Mental shock and agony.
That was another reason. They are very poor person.
This is the only ground.
Sir, in the point number 2,
Yes, read out.
on 8 December 2019, petitioner came to RCT and contracted one lawyer, Manas Datta Chaudhary, who verified all the documents, papers.
You are reading paragraph?
The one which I have filed at RCT, 17-2.
17-2 application. Yes, paragraph
2. Point number 2, line number 11. On 8 December 2019,
yes.
the petitioner came to RCT and contracted with one lawyer, namely Manas Datta Chaudhary, who verified all the documents, and thereafter with and
No, why there is a delay since 2014 to 19?
that whosoever has typed has not written the main fact, but after that tenure, when that Manas Datta Chaudhary has got the application, from thereafter he has mentioned the story. But they have received the documents at 2019. All these Hindi documents they have received. And thereafter translating all the documents from Hindi to their own language and understanding and preparing the claim application, they took the delay.
That can understand, but what is the why?
That point, whosoever has prepared the draft.
So, come to the impugned judgment, impugned order.
They had talked about the petitioner have only filed photocopies of the documents and did not file the police report or journey ticket. The final report, we even on the certified copies, we have not received the final report. The DRM report they have submitted, from there one para we have stated about the final report. The same certified copy we neither had received after doing the RTI, even doing the challan forms. And the ticket itself, everything was lost, and the DRM has also stated that everything was lost in the same. Thereafter, nothing was recovered from him, no bag, nothing was recovered. Thereafter, the parents, because they have got the number, so they have inquired from the railway registry board, or from there they have got a slip that has been attached with the filing, main filing. The tribunal has mentioned that if such long period has been taken, then they would not prepare a DRM, meaningful DRM. But DRM has already been prepared and submitted before the court. proper DRM has been submitted before the court with every points required.
Yes.
The main point was that they could not, if this could be have been allowed at such place, then they could not prepare the DRM report or meaningful DRM could not be produced, and that would be an injustice to the respondent. But in this case, already DRM has been submitted to in the and it is lying with the record and as well as with us also. So our DRM is prepared along with the final report. They have stated every point that is required for the case. So there is already then that should go on a merit. And such they are very poor person and such inordinate delays for such persons may be condoned if the case has a merit. And already they have accepted such things, such points. Their only dispute was about the ticket. And that cannot be a ground for dismissal of the case.
What's your ground for appeal?
My ground was that my ground was these people are very lay people, like lay man, and they are coming from a rustic village to condone the delay. My prayer was to condone the delay. Condone the 17th. And to hear the case on a merit, and the judgment will be passed on that merit.
Yes. Acha. Should I? Anta? Yes, who is appearing on behalf of the railway? Hard in part. Fixed on Monday. Please take down. Due to some technical error, learned advocate appearing on behalf of the General Manager, Eastern Railway, could not place his argument. According the matter is urgent today. List the matter on Monday, 8th, for further hearing.
This is my appeal. Appeal filed by the insurance company. There are two applications. One is can number 1 of 2023 is the stay application.
Yes.
Interim stay was granted. I have already deposited the entire award sum together interest before this honorable court. And can 2 is their application for Ujjwal. My can may be disposed of since I have already deposited the entire sum alert.
Your can is can 1
1.
and can
My
2.
can two. Can two is for my client.
Noting is there for the deposit.
Yes,
Can two is filed by respondent,
where is can two?
can two. For withdrawal of deposit.
Can two.
Yes. And also I have filed one court that has not been listed. For enhancement,
So I'm prepared. What is the necessary to withdraw the matter? Let me dispose of the matter.
my lord,
It will be better.
if it is possible, then it is
my lord,
no problem. But this,
my lord, here, my lord, I have, my lord, taken
What
a
about the
doubt for,
LCR?
LCR, my lord, not record, my lord, the entire certificate copy. is with me, my lord.
Okay.
My lord, my main challenge is, my
You
lord,
prepare the paper book.
that can.
my lord, one thing, my lord, my main challenge is, my lord, regarding DL, invalid DL. My lord, I have, my lord, filed a notice of appeal upon the respondent number 3, that is the owner of the vehicle, that is on 21st August 2023. I don't know whether the notice of appeal has been served upon the owner or not, because service is necessary. Because I shall pay for my lord, recovery order from the owner of the vehicle. But that may be ascertained, my lord.
LCR received.
Yes, my lord. We can think that the notice of appeal has been served or not.
No report.
No report. And then, my lord, kindly ask the department to furnish report regarding service upon the owner of the vehicle. If it is served, then, my lord, I shall proceed with the merit of the matter.
Owner is the respondent number
On respondent number 3, my lord.
3. Very well. Please take down. In pursuance to the order of this court dated. Now, where is the affidavit of service?
My lord, since my learned to is application, my lord,
Okay. In pursuance to the order of this court dated 19/5/2023, the insurance company has deposited the entire awarded sum amounting to rupees 94,67,871 by OD Challan number
693.
693 OD dated 12/6/2023. Next para. Considering the compliance made on behalf of the insurance company, the interim order of stay passed by this court on the earlier occasion is hereby made absolute and be extended till the disposal of the instant appeal. Accordingly, Can 1 of 2023 is disposed of. Next para. Can 2 of 2023 is filed by the claimant respondent number
1 and 2.
1 and 2 for part withdrawal of the deposited awarded amount. Stop. It appears that the appeal is otherwise ready for hearing. Accordingly, the application for part withdrawal of the awarded amount shall be considered at the time of shall be considered along with the disposal of the appeal.
My lord, I have filed one cross objection.
Stop. The learned advocate, Mr. Mampaniano, appearing on behalf of the respondent number 1 and 2, submits that one cross appeal has been preferred against the
55 of
instant
20
appeal being number
55 of 2023.
Court 55 of 2023. The department is directed to list the court along with the instant appeal. It appears that the LCR has already been received by virtue of order of this court. Stop. No report is there regarding the service of notice upon the
Respondent number 3.
respondent number 3. Accordingly, department is directed to file a report whether the notice of appeal upon the respondent number 3 has served or not. Stop. Let the matter appear in the list under the heading of hearing on 6th of February, along with the court.
Minimal action served,
Not necessary.
My lord, item number 5, I am appearing on behalf of the applicant insurance company led by Mr. Chandra. This is an application for stay. We have already deposited the statutory amount of rupees 25,000.
The instant appeal has been preferred against the judgment and award dated 24/12/2020, passed by the learned judge. What is the number?
My lord,
number.
Given number 426 of 21. Justice Amita Sinha appeal চলে এসেছে আমার কাছে। 426 of 23. কমপ্লিট গেছে মেমো দেখতে গিয়ে দেখি কম The 21 চলে এসেছে intra-court appeal, writ appeal has appeared. Let it be listed properly. Intra-court appeal has been appealed. Yes. Next.
Number 6.
Yes.
My lord, my application for stay. This is the affidavit of service, ma'am. My lord, the certified copy has been filed, which report has not been furnished by the SR department. My lord, I have the status report, my lord.
It was sent to the Lok Adalat.
Yes. It was not settled.
Not settled.
Not settled. My lord, the status report, I have filed the certified copy, bottom line, ma'am.
Yes.
I have filed the certified copy on 18/12 bottom. judgment was passed on 9th October 23. So I have filed the memo on
Very well. Please take down. The instant appeal has been preferred against the judgment and award dated 9th day of October 2023, passed by Learned Judge, Motor Action Claim Tribunal, Alipur, South 24 Parganas, in MSC case number 152 of 2007. Stop. Certified copy of the impugned judgment was not filed along with the appeal memo of the appeal. Stop. Learned advocate appearing on behalf of the appellant submits that she has already preferred for the certified copy, but yet to receive the same.
No, my lord, I have already filed the certified copy.
You have filed
Yes, my lord. See the status report, my lord.
certified
Bottom
copy.
portion.
Okay. Where is the certified copy?
It is not. It has not been tagged. I have already status report is there, my lord.
Okay. He has already filed the certified copy with the department on 18/12/2023.
My lord.
Stop. However, the certified copy was not tagged with this report, with this file. The department is directed to submit a report regarding the status of the certified copy and regarding the fact whether there is a delay.
My lord, there will be no delay, my lord, because on 9th,
Let them report.
my lord, the stay is very much required, my lord. It will be infructuous, my lord. See, my lord, it's
No, I am passing the order, but they have to submit a report. The stamp reporter has to submit a report. Stop. Delay in preferring the instant appeal or not. Stop. The department stamp reporter to furnish report within the returnable date. Stop. Next paragraph, can 1 of 2023. This is an application for stay of further proceeding of the impugned judgment and award dated 9th day of October 2023. Learned advocate for the appellant submits that he has deposited the statutory sum of rupees 25,000 with this department via OD Challan number 307 dated 9/12/2023. 19/12/2023. Stop. The insurance company is ready to deposit the entire awarded sum for the purpose of speedy disposal of the instant appeal. Stop. She further argued that if at this juncture the further operation of the impugned judgment and award is not stayed, the sole purpose of the filing of the instant appeal would be frustrated. Stop. Next, considering the submission made by the learned advocate for the insurance company and also considering the readiness and willingness on behalf of the insurance company, there shall be an interim stay of the impugned judgment and order dated 9th October 2023 till February 12th, 2024. Stop. The insurance company is directed to deposit the entire awarded sum less the statutory deposit within that time, within that period. On such deposit, the interim order of stay shall be extended till the disposal of the instant application, following which the interim order shall be vacated automatically. তারপরে on such deposit, the office of the land registry in High Court Calcutta shall invest the same according to the prevailing rules. Insurance company is directed to serve the application upon the respondent and file an affidavit of service on the returnable date. Stop. Let the matter appear under the heading of the application on 19th of February.
My lord, I'm grateful.
Affidavit of service filed on behalf of the applicant statement. এটা নিন। Next. 166.
Yes, my lord, I'm for that. The certified copy, subsequently, after getting the copy from the on first, second January. But I have deposited the statutory deposit after the education start, the case is already started.
Okay, please take down. Initially, the instant the instant appeal has been preferred against the judgment and award dated 6th September 2023, passed by the learned judge, Motor Accident Claim Tribunal, Tamluk, Purbo Medinipur, in MSC case number 47 of 2022. Stop. Initially, the memo of the appeal has been preferred along with the court copy of the award. Stop. Mr. Bhumik, learned advocate appearing on behalf of the insurance company, submits that the certified copy of the impugned award has already been deposited, already been filed with the department. Stop. The department is directed to submit a report regarding the fact that whether there is a delay or not in preparing the instant appeal. Stop. Can one? This is an application for stay of operation of the impugned judgment and award dated such a it would be appear. You have to deposit within 12th of February. The matter will appear on 19th. Okay.
Lordship.
At my turn. Wait.
Yes.
Lordship, the last yesterday, Mr. Bhumik concludes his submission and
Well, only
some judgment.
I have taken that point of private place and public place. Your lordship asked,
Yes.
told me that since I have not taken, I have make a submission that admitted fact need not be proved And
Yes, public place and private place,
Okay.
you have stated,
that I-
section 2, subsection 34 and 147B.
Since your losses are raised in question that since I have not taken in the plea and I have not proved about considered this my submission before this, so it cannot be asked before the appellate court. To that extent, madam, I might make a submission that admitted fact, the place of accident.
Admitted fact need not be proved.
That is section it is supported online judgment, and if your lordship trouble you, only one. It is 2009 volume 5 so Supreme Court cases
No,
141.
you have already argued regarding Dipal Girishbhai Patel.
No, that is Solibai Soni, that is the scope of the beneficial legislation cannot be extended.
Yes.
But here only
Darokanandan Agarwal.
it is 2009-5 Supreme Court case 136, Bhuvan Singh versus Oriental Insurance Company, paragraph 22. It is now well settled in law in view of section 58 of the Evidence Act that facts admitted need not be to be proved. The place of occurrence of the accident is admitted by the claimant, so I need not be.
No, whether it is admitted to be a private place. This is the issue here.
That is the question of law.
No, not question of law. Mixed question of law and fact. How can it be raised now? This is my only question.
Yes, Your Lordship. My humble submission, this is a question of law in view of the fact within the precincts accident happened, within the premises of the company, not in the public place. So any company, so that is the admitted fact that accident has happened within the premises.
This is not admitted fact, Mr. Bhumi.
That is admitted. I am
not admitted fact to be a private place.
My humble submission before Lordship that this is a question of.
But evidence is there, the private vehicle and public vehicle both running on the same place.
In the but premises within the premises, that is admitted, not the beyond the company premises, within the premises of the company. That is the admitted. And another decision Supreme Court said, if it is a question of law, then it can be asked when the people that is
admitted. Only question of law and question of jurisdiction can be asked at the stage of appeal.
The question of law. My answer, this is the place of occurrence is that. I need not trouble your lordship. Only I and others. So for the dependency, I have cited some.
Yes.
Your lordship. Now yes, I'm grateful.
Lordship, regarding the question of public place and private place, but here Lordship is the main gate at the at that time when Maruti van dashed was the main gate because of he's not entered into the gate entered into the premises before the at the time of entered into the premises that accident happened. So it is absolutely public place, and the learned tribunal did not determine the issue, and they did not prepare an appeal on that score. The learned tribunal determined the issue. So that question has no legal aspect in this regard. And Lordship kindly see that they have put the question to the victim, to the claimant, who is not the ocular witness, but who is the eyewitness. She did not put this question. Who is the eyewitness who was present at the occasion? She did not put the question. Who is the vehicle? Because of there is the front of the main gate. Front of the main gate is the public place. If there was the main gate, then how the Maruti van will cross? If it's the interview, so question is doesn't rise if the public place has been determined. And Lordship, the next question is that the Mr. Bhumik also placed one judgment of our Calcutta High Court Justice by Justice Dipankar Dotto. Lordship, pardon me, I am taking the Lordship's name. Here, Lordships, the case is absolutely otherwise. My case is that there is the daughter. The daughter has come before your Lordship, and in this case, Lordship, the brother and sister has come before your come before this honorable court, come before the learned tribunal. Subsequently, they appealed with the insurance company and then contested the case. To that extent, Lordship will decided that if the brother and sister has come in the claim compensation, in what extent that has to be awarded. After considering the all aspects, our honorable division bench awarded 50 lakhs. Awarded 50 lakhs. Lordship, what is the examination? Income, multiplier, multiplicand, future prospect in such way. So after considering the multiplier proceedings, adopt the multiplier proceedings, the learned may come to a conclusion is 1 crore 22,000 to 2 lakhs is the award of the division. Ultimately, the Justice Doctor decided the issue in such a to that extent can be awarded. To that extent, lordship can be awarded 50 lakhs without any computation. Who are they? They are the brother and sister.
Married brother and sister.
Married brother and sister. But here is the daughter is the claimant. So how this case is applicable in this case? And as well as lordship, I have also placed one judgment before your lordship, the just order passed by Justice Patnaik. In the same case, the Patnaik decided the issue. And lordship, kindly come to judgment of Justice Dotto, paragraph 17. Having paragraph 17.
Yes.
Having submitted aforesaid aspect the matter, reference was made to the Act 13, Section 1. Therefore, obtained that the claim should be confined only for the benefit of the wife, husband, parent, and child, if any, of the person whose death has been caused by the accident. That is the law. What is the departure? Departure is that any brother, sister is entitled to get the compensation or not. The justice have decided the issue. Yes, they are entitled to get the compensation to that extent. That is the ultimate observation of the honorable division bench. But here is the daughter has come, her mother died. And lordship, the question of dependency doesn't arise in the Motor Vehicles Act. If suppose they are not at all dependent, then what will happen? If the person get the compensation appointment, then question of dependency doesn't arise. If the minor child died, the parents are come before your lordship asking for compensation. There is a question of dependency. Simply stated is that person died according to section 166. The legal representative has come approached before the concerned tribunal for asking for compensation. And also the case that in this case, lordship Justice Dotto judgment, here prior to that the father and parents of the claimants before the landed tribunal, parents of the claimants before the landed tribunal, during proceedings, the parents and both the parents died. Subsequently, the brother and sister has come. So they are consolidated to that extent. Last Justice the honorable division bench allowed 50 lakhs. Allowed 50 lakhs without any computation, without nothing. Because of 1 crore, 50 lakhs. But it is not that 50%, but the 50% as determined by the learned tribunal case before your lordship, he has no justification. Why 50%? Why not 40%, 20%, 0%? Why not 60%? But law is said, the statute said 1/3 deduction on the account of personal expenses had he been alive. So that analogy will be applied. The 1/3 deduction. In case of bachelor, 50%. So conception of bachelor of 50% certainly cannot be adopted in this case where the deceased was the married. Lordship, I have shown the judgment, the Sarla Verma. Lordship also seen that. Rather, Lordship also page 30, paragraph 31. That was the deceased was a bachelor, claimants are parents, deduction follows 50%, living way. Because of and in absence of any absence of evidence to the contrary, brother sister will not be considered as a dependent because of they are either dependent or running. So there my client is not brother or sister. If my client is brother or sister, then he is covered by Justice Doctor's judgment. paragraph 31 of the Flora Pharma.
Yes.
And Lordship, the learned tribunal also did not consider the future prospects. He is 56 years old. He is still in service. He is DPL. And Lordship is the government concern. He is not the private concern. Lordship, kindly see that the page. Yes. Page 43. Durgapur Projects Limited, a government of West Bengal enterprise. It's a private company. This is the company. It's not the company. It's a government undertaking from limited project. And Lordship, kindly see the next page, page 41, 44. The date of birth is 15/11/54. And then also kindly see the name, husband name, then date of birth. Lordship, got it? Third line from top.
15/11/54.
15/11/54. And the accident took place on Lordship 2011. So 56 years.
56 years.
56 years. And is still in service. So 56 years means Lordship is the 15%, no? 15%.
15%.
15%. This 15% future prospect has to be avoided. That learned tribunal did not consider the same.
That's
So
all.
my intel is Lordship. So should not be, it should be 1/3 and 15% future prospect, and also learned tribunal granted to 2,000 and 2,500. It should be 30,000.
Very good.
What I have received.
Okay, please take down. Instant appeal has been preferred against the judgment and award dated 20th April 2017, passed by the learned judge, Motor Accident Claim Tribunal, Asansol, in MSC case number 19 of 2012. The brief fact of the case is that the present appellant, being the claimant, preferred an application before the learned tribunal for getting compensation. Preferred an application under section 166 of the Act for getting compensation on the ground that her mother was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle, duly insured under the policy of the insurance company. Stop. The claim case was contested by the insurance company. The learned tribunal, after hearing the parties and after receiving the evidences, has allowed the compensation in favor of the claimant to the tune of rupees 5,51,700. Being agreed by and dissatisfied with the said award, the present appeal has been preferred by the claimant. Stop. The learned advocate for the next part, the learned advocate for the appeal submits that the impugned judgment and award passed by the learned tribunal is erroneous. It submits that it would be revealed that the deceased was aged about 56 years old and he was engaged in a government job under BPL company. She used to earn rupees more than 20,000 per month as a salary. The salary of the deceased has been proved before the learned tribunal. The learned tribunal has correctly assessed the yearly annual salary of the deceased to be 1,21,630. The 1/3 from the salary was deducted towards her personal expenses, and thereafter erroneously deducted 50% with the ground that the present appellant stroke claimant is the married wife and who is settled with her husband and not dependent upon the deceased. On that score, full stop, on that score, learned tribunal has deducted 50% of the annual income of the deceased. He submits that the observation of the learned tribunal is erroneous and beyond provisions of law. The learned tribunal has no authority, has no legal duty to deduct the 50% of the yearly salary of the deceased on the ground that the claimant was not dependent. Stop. We argued that the claimant is the sole daughter of the deceased. She is the sole legal heir, so she is entitled to get the entire compensation. He further argued that the learned tribunal has not considered the future prospects at the time of assessing the compensation. Also, the general damages was awarded only rupees 4,500 instead of 30,000. Stop. He submits that the just and proper compensation. Submits that the appellant is entitled to get the just and proper compensation. Stop. Next paragraph. Learned advocate appearing on behalf of the state, Mr. Vomik, submits that the instant claim application is barred under the law of limitation. Stop. The claim application filed by the claimant is not at all maintainable. Stop. It is a fact of this case that the alleged accident happened in a private place. Stop. According to the provisions of section 147 within bracket B, the application for compensation cannot be entertained when the accident happened in a public place. Stop. He further argued that the public place has been specifically defined under section 2 within bracket 34 of the said act. Stop. In support of his contention, he submitted that the claim application was filed stating the fact that the accident happened at the administrative building. The administrative building is a public place, is a private place, so the claim application is not maintainable. He further argued that by the virtue of decision of Honorable Supreme Court in Bhuvan Singh, the Bhuvan Singh, you give me the citations. Bhuvan Singh. The fact, the admitted fact need not be proved. We argued that the fact has already been admitted by the claimant himself, claimant herself. So, at this juncture, it has proved that the accident happened in the private place and the claim application is itself bar. Bhuvan Singh versus
Bhuvan Singh versus Oriental Insurance Company,
Orient Insurance reported in
2009, Volume 5, SCC, 2009.
yes. Stop. Next paragraph. Secondly, Mr. Phomik argued that the present that the learned tribunal has committed no error in deducting the 50% of the income of the deceased in calculating the just and proper compensation. Stop. It has admitted fact. It is the admitted fact that the present appellant claimant is the married daughter of the deceased. It has also been proved that the married daughter is now residing with her husband. Stop. Admittedly, the married daughter is not solely dependent upon the income of the deceased mother. Rather, she is dependent upon her husband. So on that score, there is no error apparent in the impugned judgment. Error apparent in the impugned judgment. Stop. In support of his contention, he cited the decision of Honorable Division Bench of this court passed in Future India Insurance versus Soumitra versus Sumita Roy and another, wherein the division bench has considered the application, considered the appeal of the insurance company and is of view that the married brothers and sisters are not entitled to get the entire compensation. Stop. On that, in that case, the learned tribunal has awarded a sum of rupees 1,22,62,015, and after considering the entire aspect, the Honorable Division Bench has only awarded 50 lakh in favor of the married siblings. He also cited the decision of Honorable Supreme Court passed in Civil Appeal passed in New India Insurance Company Limited versus Anand Pal and others, arising out of SLP Civil number 7805 of 2022, wherein the Honorable Apex Court has held that the married siblings are not entitled to get any compensation. He also cited another decision of Honorable Supreme Court reported in Anju Mukhi and another versus Satish Kumar Bhatia and others, within bracket 2010, 15 SCC 630, wherein the Honorable Apex Court has held that the dependency has lost when the wife got remarriage. Stop. The citing by citing all the decisions, the Honorable Mr. Bhomik argued that in all cases of compensation, the dependency is a factor. Stop. According to the decision of Honorable Supreme Court in Sarala Verma, the learned apex court also considered the dependency factor. In this case, the learned tribunal has correctly considered the dependency of the instant appellant and has correctly deducted the 50% of the income. Stop. On that score, the learned advocate for the appellant submits that the ratio decidendi of the judgments placed by the learned advocate for the appellant is not at all applicable in this case. By the decision of Honorable Division Bench of this court as well as the Honorable Apex Court in HON'BLE, the learned courts have considered the compensation in respect of the married siblings. But in the present case, the appellant is the married daughter and who is the sole legal representative of the deceased. So the ratio of decision of Honorable Apex Court as well as the Honorable Division Bench is not applicable in this case. He further pointed out the paragraph 31 of the decision of Honorable Supreme Court in Sarala Verma versus Delhi Transport Corporation, wherein it has been mentioned that in case of bachelors, normally 50% is deducted on personal and living expenses, but in case of married person, the deduction would be 1/3 or 1/4 or 1/5, considering the member of the family. Here again, I argued that the coordinate bench of this court has decided the issue to the effect that the 50% deduction is only in respect of unmarried persons. Stop. Heard the learned advocates? Where is the material for? In considering the first question raised by the learned Mr. Bhumik regarding the maintainability of the claim application, it appears that the learned tribunal at the time of disposing of the claim case has framed as many as 7 issues, wherein the issue number 1 is framed that whether the claim case is maintainable or not. Stop. The issue of maintainability as raised before this court has never raised before the learned tribunal. Stop. The learned tribunal has decided the issue number 1 in favor of the petitioner. Stop. Next paragraph. The insurance company has not filed the written statement specifically on that issue, that the alleged accident happened in a private place. No question or suggestion are put to the evidences, to the witnesses regarding the fact that the accident happened in a private place. Stop. Next slide. By virtue of decision of Honorable Supreme Court in Bhuvan Singh, it is true that the admitted fact need not be proved. Stop. Let me consider whether the fact that the accident happened in a private place is at all admitted by the parties before the learned tribunal. In plain reading of paragraph 23 of the claim application, it appears that the accident happened on 4/1/2011 at about 3:45 p.m. when the victim was entering into the administrative building. Stop. The insurance company has contested the case by filing written statement along with an application under section 170 of HON'BLE Act. The written statement of the insurance company never raised the point that the alleged accident happened in a private place. The appellant was deposed as PW1 before the learned tribunal. During the cross-examination of the appellant by the insurance company, it came to the light that the accident took place at the DPL gate in between main gate and 1 kilometer distance from administrative building near the railway. It has stated by the PW1 during the cross-examination that both the private and public vehicles used to ply on the same place, used to ply on the ply over the same place. During cross-examination of eyewitness within bracket OPW2, no questions were put, no suggestions were asked or put was put by the insurance company to the fact that the accident happened in a private place. Stop. Next. After scanning the pleadings and evidences of this case, it appears to me that the question raised by the learned advocate for the insurance company is a new fact which can only be determined by adducing proper pleadings and proof. Stop. The insurance company has failed to adduce any pleadings or proof before the learned tribunal regarding such issue. Stop. The next part. The question of maintainability can be raised before a appellate court when within bracket A, when there is a when the maintainability can only on the basis of law, and B, when the jurisdiction of the learned trial court is in question. So, in that the issue raised by Mr. Bhomik is a mixed question of law and fact. The question cannot be re-agitated before this appellate court. Accordingly, I find no justification to entertain the issue at this juncture. Stop. Next, in considering the second issue of dependency, it appears to me that the learned that the Honorable Division Bench as well as the Honorable Apex Court has decided the issue of dependency in respect of married siblings. Stop. The paragraph 31 of the decision, paragraph 31 of Sarala Verma versus Delhi Transport Corporation need be set out for the said purpose. Stop. 31 to paragraph 31. It has been specifically observed by the Honorable Supreme Court that set out for it has been specifically observed by the Honorable Apex Court that in absence of evidence to the contrary, brothers and sisters will not be considered as dependents. Stop. Thus, the issue has already been decided, and it has already been decided by the Honorable Apex Court in several decisions. Stop. In considering the dependency of the present appellant with the deceased, it appears that the present appellant is the married daughter of the deceased. It is true that the married daughter is staying with her husband. The appellant is the sole legal heir of the deceased. The mother, the responsibility is mother, is always running towards their child till her death. So in that score, it is well presumed that the present appellant, being the only daughter, is no doubt the dependent upon the properties as well as the dependent upon the properties of the deceased. Stop. Considering the same, it appears that the learned tribunal has committed error by deducting 50% of the yearly income of the deceased. It appears that the just and proper compensation, in considering the just and proper compensation of this case, the yearly income of the deceased comes to rupees 1,21,000. In considering the just and proper compensation of this case, the award passed by the learned tribunal need be modified. Just and proper compensation is recasted as follows. After calculation, the award comes to rupees 8,69,250. The tribunal has already awarded rupees 5,51,700. the balance order comes to rupees 3,17,550. Stop. The insurance company is directed to pay the balance award along with 6% interest per annum from the date of filing of the claim application, that is from 27/6/2011 or 2011. Stop. Within 6 months, within 6 weeks from the date of passing of this order through the office of the Learned Register Judge, High Court, Calcutta. On such deposit, the claimant is at liberty to receive the same whether you have deposited the.
Yes, Lordship, unless the check cannot be handed over by Learned Tribunal.
No, how many you have deposited?
13 lakhs. The Lordship ordered ultimately 8 lakhs.
Your claim was 13 lakh.
Yes, that are those who court cases deposited.
But the impugned award does not stated like that.
Lordship, was that unless and until they deposit the court fee, the certificate copy will not be allowed by the tribunal.
No, you may have deposited the on the awarded sum.
Yes, only 13 lakhs. But my Lordship was awarded.
PF paid is correct. Such type of order is not there.
That line is not
yes,
there.
that order is not there. That's why I am asking.
The Lordship is absolutely perfectly correct. That order is not there.
That order is not there. If any, okay. Receive the same. Receive the same. So, according to the prevalent rules, subject to ascertainment of payment of deficit court fee, if any.
Not paid.
Applications. साला फॉर्मेट लिखना yes next
Madam,
But I am for the respondent claimants.
My lord, Mr. SUBHENDU is appearing on behalf of the applicant insurance purpose. My lord, we kindly note not to discuss all has left the court to attend an urgent meeting in the county.
item number
11.
11.
I'm for the respondent claimants.
Okay, count Monday.
Monday at the top, my lord, please.
It would be appear on top.
I'm grateful to you.
Number 12, 14, 14.
I have served the paperwork.
I'm led by my
So ask him to do in the Rajarhat court. You do the matter. Such type of submission cannot be maintained before the High Court. You may be engaged in anywhere. You take note. I have heard the matter. Thereafter come on Monday. Okay. Start.
But there's a delay application, 31 days delay. I have served also copy of the delay application. Allow here. I'm sorry, I'm sorry for
No. That has been disposed of.
That's not in this one, I'm sorry.
That has been
Thereafter paper book direction as well.
Yes,
So
yes.
kindly come to page 43. The impugned judgment. And this is with regard to non-granting future.
You take note.
This is with regard to my lord only in respect of non-granting future prospect and income. The landed tribunal, tribunal below hold the income of the deceased 3,000 per month instead of 6,000 per month. Page 43, it starts from page 43. Stated, my lord. Can you come to page 45? Page 45.
Yes.
Dated 23rd February 2021. And everything has been taken note of. Can you kindly come to page 47, running page 3. What are the document exhibited? Prior that, well, witness examination. That is PW1 Maloti Tudu, the wife of the deceased. Page 47. Maloti Tudu, the wife of the deceased. The claimant number 1 hearing. The Shopon Pal eyewitness and Akhtar Ali Bangi being the employer of the deceased. Now, what are the document has been exhibited? Exhibit 1, my certified copy of the FIR. 1A, 2 copy of the written complaint, such and such. I am not on this one, all this. Now you will see, kindly come to page 48, next page. Income certificate of the deceased, exhibit 12.
What is the occupation?
But he was a khalashi of a trap. A income certificate has been exhibited exhibit 12.
Income certificate, exhibit 12.
Yes, well, page 35.
Income stated 6,000.
6,000. You will also kindly come to page 35. আমি আখতার আলী ভাঙ্গি মিতাপিত মোবারক ভাঙ্গি সাং মেটাডহর পূর্ব পোস্ট গুয়াইদহ থানা গড়বেতা জেলা পশ্চিম মেদিনীপুর এই মর্মে প্রশংসা দিতেছি যে গোপাল টুডু দি ডিসিস্ট মালট পিতা শ্রী বদ্রীনাথ টুডু সাং সাচা সাচা আমার একটি ট্রাক যাহার নম্বর WB330044 তে খালাসি হিসেবে প্রায় 5-6 বছর যাবৎ কাজ করিত। তাকে আমি প্রতিদিন 150 টাকা মজুরি বাবদ এবং খোরাকি বাবদ 50 টাকা করিয়া মোট 200 টাকা হিসেবে মাসে 6,000 টাকা প্রদান করিতাম।
So learned tribunal has adopted 3,000.
3,000. I am coming to that. Now you also kindly come to issue number 5 and 6, page 50.
Yes.
Since the now prior that you will also kindly come to examination of PW3 being the owner, page 21. We've also got it, page 21.
Yes.
This is Gopal Tudu used to work as Khalasi in my truck, such as from the year 2008 to that till date. I used to pay rupees 6,000 per mensam as salary. I issued the certificate with certificate regards to his income. This is my said certificate written by my manager Yunus Molla and signed by me. The certificate is marked as exhibit 12.
Yes.
And there cross-examination, my lord, it has been mentioned, it has not been mentioned in the certificate who subscribed it. In the chief, my lord, he has said that his manager has signed it. Now, I do not maintain a salary register of Khalasi driver and staff. As per request of the claimant, I issued this certificate. I do not have any personal knowledge of the alleged accident. Not a fact. I used to pay rupees 6,000 per month per mensam to the Gopal Tudu as Khalasi. Not a fact. I have deposed falsely. Now, your lordship, kindly come to the impugned order, decision with reason. Can come to page 51.
Yes.
Page 51. According to the future purpose of calculating the third paragraph.
Yes.
I may take the amount amount of income of the deceased according to the evidence available before the court, which is 36,000 per month, 3,000 per month. And I should take 1/4 has been deducted 9,000 from the amount of considered personal expenses on the day of expense. So the income to the figure to the tune of rupees 27,000 per annum as contribution by the deceased towards the family. Now, considering the age of the deceased being 30 years plus, I should apply multiplier 16 by applying the multiplier 16 compensation on account of the loss of future funding is worked out as 4,32,000. No future prospect has been granted. Future prospect and real damages to the tune of rupees 70,000 has not been granted.
No, general damages was given.
No, madam. I had one
Consortium 16,500.
16,500 as funeral expenses of the deceased, rupees as consortium, and rupees as loss of estate. So the total amount of compensation come to 5,09,000. That is I am already at the point of income and future prospect. Right.
Added 33,000 plus 44,000.
Right.
Excess.
So far 16,500 funeral expenses.
16,500 funeral expenses,
Consortium
44,000 consortium, and further 16,500 for loss of estate.
Loss of estate.
That is come under the same heading.
Then that is come to the 44 plus 60.
44 plus 33. 77,000.
No future prospect has been granted.
No future prospects.
And income, the London Tribunal hold income of rupees 3,000 instead of 6,000 without any contra evidence, without anything. And
what is the date of accident?
The date of accident was 22nd January 2030. That your lordship will get it at page 5. Serial number 8, column number 8. Page 5, column 8. Over the road of Kongsaboti, Kanpur on 22nd January 2030. Have your lordship verified?
Yes.
And the dependent
Age was?
Age was 36 years. And I am into 40% future prospect. 36 age of the person, page 4. So let's will get it. And the
voter ID?
I am coming. Page 30A.
30A. 30A.
Age as on 2005, 23 years.
$46 years. 36 years.
36 years. Well, that has been written also.
36 years.
Page 4, you will get it. Page 4. Age of the person 36 years.
36 years.
Column 3. And my lord, the dependent are the wife, minor child, and parent. Claimants.
Hmm.
Two, 3, 4 are the minors. They are represented by the national guardian mother. Claimant appellant number 1. 5, 6 are the
multiplier adopted 16.
16, my lord.
It would be 15.
It should be 15. No possible as in preferred, my lord. Anyway, that has to be.
Yes.
That has to be.
Very well, very well. That's all.
That's
Come on Monday,
instead of Monday, can it be Tuesday or
Tuesday.
Tuesday?
Okay, please take down. The matter heard in court.
Well.
Let the matter fixed for further argument on 9th of January 2020 at the same position.
Huh? Last section.
I'm for the insurance company. Item number 15, I am for the insurance company. Lordship.
Item number 15, you are for the insurance company. Yes, Mr. Roy is there. Have you received the paper book?
Yes, Lordship. Just 1 day back I have received paper.
Okay. So where is Mr. Roy?
He was rightly here.
Very well, not today. Come on Monday.
Grateful.
19, my lord. I am happy with the appellant. Claimant is the appellant. Injury case, my lord. This is
Who is for the?
Mr. Pahari is appearing.
Okay, Mr. Pad is there. Huh?
This is injury case, my lord. Disability to the extent of 30%. My lord, paper book I have filed, my lord.
3,53,000.
Yes.
789.
Yes.
You have received the award.
Yes. That has been received.
So what is your ground?
My lord, at the time of calculating the compensation amount, the process has not been followed. And my lord, the medical expenses which has been disbursed by the employer concerned to the extent of 1 lakh something, my lord, that amount has been deducted. That should not be. Even if, my lord, the person who had, my lord, medical policy, the policy, medical policy, if I hold medical policy, my lord, on that basis, my lord, disbursement has been given. That amount should not be deducted because it is statutory liability upon the insurance company. If there is any, my lord, disbursement has been done, that contract is violent between the.
No, what happened here?
Here, my lord, deduction has been made.
Deduction has been made in respect of?
My medical expenses which has been disbursed by the employer.
Employer has taken the liability of medical expenses.
Medical.
So why you are claiming?
Well, that
you have not, there is no loss for you regarding such medical expenses. Why you are asking?
My lord, medical expenses has been given through medical policy. Whether it should be given or not.
No, if you think that I have admitted,
division bench has assessed this. I am coming.
In this case, whether what happened, employer has taken the
not
cost.
entirety.
Whatever may be. Yeah. So why you are again asking?
My lord, that medical expense has to be disbursed by the insurance company.
Medical expenses
has to be disbursed by the insurance company.
Who shall get it? The employer shall get it. No. If insurance company is liable to pay, then the employer will receive it. You are not. Yes.
No, my lord. That
you will not
decided our High Court. Division bench of this honorable court has been assigned.
No. Okay, let me first.
My lord, at first, my lord, kindly see age of the victim was 55 years.
My lord, come to page 20.
Yes.
20?
Rightly.
24. Yes, read out.
My lord, here, not 24. it will be, my lord, helpful. My lord, 23 bottom portion, from 23 bottom portion,
Yes.
my lord. My lord, 24, my lord, 24 bottom portion, my lord, 24 bottom portion.
Yes.
My lord, from middle portion, my lord, to prove the actual age of the victim, no documented evidence is produced by the claimant. Traversing the materials on record, it appears from the physically handicapped certificate exhibit 15, the health and family welfare OPD card such and such. The victim was aged about 57 years. The medical certificate for the person with visual disability being as marked 16 shows the date of birth of the victim as 23rd October 1963. So at the time of accident, the victim Tapan Kumar Ghosh was aged about 55 years. Physically handicapped certificate shows 30%. PW2 Sukumar Sarkar, the authorized representative and in charge of medical record department of the Mission Hospital Durgapur, produced the medical bills of the victim. Tapan Kumar Ghosh admitted they are as an indoor patient from such and such date. During this period, medical bills raised hospital rupees such and such, out of which the patient party paid rupees 4,800 and the balance amount was reimbursed by the employer. The medical bills being marked exhibit 8 to 8/12. The patient was admitted in the said hospital for the second time from such and such date, and during this period, the hospital bills being marked exhibit such and such amounting to rupees 40,000 was paid by the patient. So the victim is entitled to reimburse 44,953. Now this tribunal will have to ascertain whether the claimant is entitled to get benefit of entire period of 198 days for leave encashment or not. Traversing the materials on record, more specifically exhibit 13 being the leave statement issued by the assistant personal officer Eastern Railway Asansol goes on to show that the victim was on leave such and such and in cash 31st March 2018 to 30th March 2019.
Yes.
The encashed 198 days of leave. The fact is also borne out from the evidence in chief of PW3 Sanjeev Kumar Mukhopadhyay, a representative of Eastern Railway Asansol division, but this witness during his cross-examination expressly deposed that on 15th June 2018, the Mission Hospital Durgapur issued a certificate stating that the patient was fit to join his duty as trains clerk, Eastern Railway. So at best, the patient is entitled to get the benefit of 76 days on account of leave. The payslip for the month of March 2018, exhibit 11/2, goes to show that the gross salary less professional tax is rupees 74,744. Thus, his salary was 2,411 per day. Therefore, the total loss of income during hospitalization comes to rupees 1,83,236. That calculation has been done.
For 76 days.
For 76 days. For 76 days.
Yes.
At last, but on the list, the tribunal has to be ascertain whether the claimant is entitled to get benefit loss of earning capacity after retirement or not. On hypothetical basis, the victim would be capable of earning rupees 3,000. Madam, kindly see this per month, and he not been suffered disability to the extent of 30%, thus taking the actual income 36,000, applying multiplier 7 as per Sorla Pharma. And after retirement, that fact has come. Thereafter, my lord, the casual versus applied, and only 25,000 has been assessed towards pain and sufferings, and total amount to rupees
50,000.
50,000 for loss of comfort, etc. Here, my lord, total amount compensation of 3,53,789 rupees. Rupees 1,80,000 is the loss of income during hospitalization, 44,000 medical expenditure, 75,600 total future earning, loss of future earning, 50,000 loss of comfort, etc. My lord, in this way, my lord, calculation has been made. কি আছে? না না আমার কাছে কিছু নেই,
দেবেন না
আমার কাছে নেই, আমার কাছে নেই। জজ সাহেব জানেন গো।
Yes. What is your submission?
My submission is that, my lord, here, my lord, from PW1 is the victim. And Mission Hospital, my lord, can you see page 10? Page 10, Mission Hospital, 1,35,000 medical expenses. My lord, that has been, my lord, discussed in the judgment.
Yes. You have already just read it.
Yes. Here, my lord, kindly see the cross-examination of the employer.
Page.
My lord, page 12. My lord, kindly see entire deposition should be taken into consideration.
PW2 is the eyewitness. No, PW2. Who is the PW2?
PW2 is the employer.
Employee.
This day, I appear before this tribunal to represent my office, the Eastern Railway Asansol Division, pursuant to the summons issued by this tribunal and being duly authorized by the Assistant Personal Officer, Eastern Railway Asansol. This is the authorization letter wherein my office authorized me to depose here, and it bears my attested signatures. Authorization letter mark exhibit 10. This day, as per summons requirement, I brought the 13 pay slips of the employee Tapun Kumar Ghosh. For the month of January, as per pay slip, his gross pay was rupees 2,26,760, which is inclusive area of such and such. Net pay rupees 2,07,978, which is also inclusive area. There was income tax deduction rupees 5,000 such and such. This is the pay slip for the month of January 2018, being marked as exhibit 11. For the month of February 2018, as per pay slip, his gross pay was rupees 74,974. Net pay 33,178. There was income tax deduction 36,000. This is the pay slip for the month of February 2018, being marked exhibit 11.1. For the month of March 2018, as net pay slip, his gross pay was 74,974. My lord, that has been, my lord, marked in the judgment. 74,970. Net pay 69,000 such and such. This is the pay slip for the month of, and all this has been given. Thereafter, my lord, kindly see the cross examination next page. During the leave period, the employee got his salary in full. I have no personal knowledge as to whether the employee got the medical bills reimbursement or not. Even if the hospital issued a fee certificate, the LOA medical board on its own constitute its own medical board, which decided as to whether the patient is fit to work or not. And if the board decided otherwise, then the patient has to take the leave on average pay. As the accident did not occur during the course of his employment, and the same is non-remunerative for the employment, I have no personal knowledge regarding the opinion of the Railway Medical Board. As per leave statement, though the patient took leave on 1/4/2018 and his leave on average pay till 12/10/2018. Therefore, he joined his duty and again took leave on average pay from 12/3/2019 to 14/3/2019. On 15/6/2018, the Mission Hospital Durgapur issued a certificate stating that the patient was fit to join his duty as train clerk, Eastern Railway. Not a fact that the doctor, in spite of issuing fit certificate, the patient chose not to join his duties. My lord, the office concerned merely, my lord, issued a certificate by the hospital, the railway concerned, that is the rule. That is their rule. In consequence, it has come.
Where is that certificate?
My lord, at the time of cross examination, nothing has been my lord, asked to put or not. To put or not.
What are you arguing? What do you want
My
to
lord,
prove?
my argument is before your lordship.
What do you want to prove?
My lord, here calculation at the time of calculating the compensation amount, my lord, the structure formula has been taken into consideration.
Why are you showing this cross examination and everything?
My lord, because my lord, 76 days has been given by the by the tribunal below instead of 198 days.
Instead of
198 days.
where is your calculation about 198 days?
2411 into 198 days.
No.
Only 76 days has been applied.
He has adopted in case the leave of 198 days, full leave.
Total
190 days he has received.
Yeah, therefore the total loss of income. My lord, here kindly see the calculation. 76 days.
25.
25.
Page
In the middle
25.
portion. In the middle portion.
Victim was on leave from 31/3/2018 to 33/2019, and in case 198 days leave.
My lord, here, my lord, in the bottom portion, that paragraph in the bottom portion.
Yes.
Therefore, his total income during hospitalization comes to such and such. My lord, that has been multiplied 76 into 2411.
up to the date of fit certificate granted.
My lord, that
Mission Hospital.
Yes, for that disease, I have merely because my lord, I released from hospital, I was not fit to join the duty.
That's why you are given the say 76 days. You have not joined.
My
That's
lord.
why you have given. That's why you have given.
My lord,
No,
as to why I could not join, because my lord, the office itself, my lord, allowed me after that. My lord, in the cross examination itself, my lord.
No, what are you arguing? I just not understand. You are given release by the hospital, and you are not given duty.
My lord,
my
argument is that 74,000. It is 74,000 his salary.
So per day 2,411.
My lord,
you admit it?
Leave it. 74,000 his salary. 74,000 is salary. My lord, if applied multiplier method, then 74,000 into 12 into 30%. This way will come. Plus future prospect.
No, whether you have joined in the service or not.
Even if, my lord, the Supreme Court what said that in this case.
So what is your disability?
30%.
What is the disability certificate?
My lord, page. Your lordship will find form.
Index
total index করে দিয়েছি। My lord, total disability, total exhibited documents index আছে। My lord, 80, page 80. This is AIMS. And here, my lord, disability from page 20, page 81, my lord, percentage has been given, my lord,
Visual disability.
yes, visual disability. Visual disability.
30% visual disability.
Yes, my lord. Visual disability. Visual disability in case of a, my lord, person who is working. ওইটাই তো আছে
কোথায় আমরা দেখা ইন্ডেক্স করো
কবে ইন্ডেক্স করবো
কোথায়
আমি বলে দিচ্ছি এক্সিবিটেড ডকুমেন্টস
ব্যাস হয়ে গেল
ইনফরমাল ডিসেবিলিটি দেখালাম তো এইসবে সব এরকম করে আপনি স্যার মেরে ফেলুন আমাকে দাঁড়ান আসছি ওটা পরে দিচ্ছি আপনাকে
এটা জল কাজে রাখো দাও
বাবা ডিসেবিলিটি
টিচার সার্টিফিকেট কামছে রেকর্ডটা
না দেখছি দাঁড়া ডিসচার্জ সার্টিফিকেট এখানে এই প্রিন্টটা দেখলেই তো পেয়ে যাবে দাঁড়া পিডব্লিউ ওয়ানে বুঝতে পারছি
Page 78.
page 78
What is this?
this is also disability certificate
So how many disability certificate you have proved?
There are two disability certificate.
Why?
Disability regarding 30%, my lord, that has been assessed by the tribunal. I am not challenging that. My submission is to the extent, my lord, kindly peruse this once moment, my lord, kindly peruse this, my lord.
My lord,
Decision
where is
2000
the discharge certificate of the mission hospital?
entire bill has been, my lord, produced. Mission hospital has come. My lord, in this case, your lordship will find, my lord, the logic. My lord, kindly see
No,
paragraph 3.
you want to argue that the structure formula has to be adopted.
My lord, my lord. This
This is your argument.
My lord, this is my argument at first, my lord. At first.
Your 30% disability is temporary disability.
There are two decisions, my lord. There are two disability. 30% has been accepted by the tribunal bill also. Visual disability, my lord. My lord, paragraph 3, my lord, I am placing. The appellant has suffered multiple fracture of dislocation of the left elbow, nailing of right tibia and femur bone. The appellant undergone several surgical procedures, including reconstruction of right elbow. The board doctor assessed permanent disability to the extent of 45%. The tribunal, while taking into consideration the emoluments of the appellant as rupees 18,941, the per month applied the multiplier 16, keeping in view the age of the appellant as rupees 32 years. Thus, the total compensation of rupees such and such was awarded, including expenditure towards physiotherapy, special diet, conveyance, loss of earning, rupees 16,000 towards future medical expenses. Such and such was on account of loss of future income to the disability. The High Court is an appeal filed by the insurance company, reduced the amount of compensation by applying multiplier 9 for the reasons that there is no loss of employment. We have heard learned counsel for the parties and find that the High Court has erred in law in reducing the amount of compensation. The appellant, though continues to be in service, but his efficiency as a constable has been seriously compromised. Therefore, the amount of compensation awarded by the Motor Accident Claims Tribunal rupees such and is just and proper.
That's why I wanted to ask you, what is the disability?
Disability 30%, visual disability 30%. Visual disability 30%. That has been accepted.
Whether it affected your service?
But that has been affected because
why? Where is the evidence?
Well, the train's clerk. The train's clerk.
Have you stated so that this was my service and now after that my income had been reduced? I have been transferred to separate position.
Even if not reduced, for that reason, my lord, he was undergone treatment for a long period, and the nature of my lord, the visual disability
is temporary.
Is temporary to the extent, my lord, what type of disability? Glaucoma cannot be cured. Cannot be cured. Glaucoma.
Whether it is glaucoma, case of glaucoma.
Accident? Yes, that has been, my lord. Kindly see the disability. Kindly see the disability here. It has been written in 80.
No, 80. What is the 74? What it is stated?
77.
78.
78. Temporary disability has been stated. Temporary disability, not to the, my lord, kindly see, not in respect of eye.
No. You see the disease. This is eye, not glaucoma.
In, my lord, in 80, your lord,
80 is the private hospital. It is not. This is the government hospital disability certificate.
Orthopedic, my lord, AIMS.
Not AIMS.
This is from AIMS, my 80, page 80 AIMS. But kindly see the top.
It was given in the year 2018.
Yes.
And latest is 2020.
2020 also 30%. There is no improvement.
Yes, temporary.
Temporary fund. There is
But
no improvement. If it is temporary, then it should be reduced. It can be reduced by passage of this time.
No, you are arguing otherwise.
No.
Where is the
This is from
glaucoma?
glaucoma, my lord.
Where is glaucoma?
Here. I have seen, my lord. I mean, page 80. I have seen, my lord.
Glaucoma never be said to be a temporary.
I have seen, my lord. Page 81, I think. Page 81. I have seen. My lord, certificate, page 81 from top, my lord, you lost it.
Illegible.
My lord, kindly see this. This is from exhibit.
Read out. What is this?
Nature of certificate. Nature of certificate in the first paragraph. Here, my lord. First paragraph, last two lines. Page 81.
This is the written form. Whether this was
written form in respect of I, my lord, not otherwise.
Whether this applicable in the pressure?
Yes, that is the written
No,
form.
my lord. Glaucoma has been stated here.
Why? Where?
My lord, here, my lord, kindly see.
Oh.
This is the form. Given form.
This is the given form, my lord. The percentage, how it has come 30%, my lord, in
Yes,
each and
this
every.
is the determination. This is the determination, seat of determination. How to be determined?
My lord, how it has come, my lord, 30%.
This is their form.
Yeah, my lord,
In the discharge certificate issued by the mission hospital, it was proved, but no discharge certificate was exhibited in the paper.
Well, that is not questionable at all. That is not questionable at all.
No, he has been discharged from the hospital.
Yes, my lord, the medical bill shows that. My mission hospital came and proved all these things.
Perhaps you are not ready on the entire matter. However, today I don't have a time.
Today, yes, my lord.
Come on Monday.
I shall place, my lord, this part, my lord, regarding 30%.
Where is the LCR?
LCR has not come.
Then how can it be? These are the several questions are there. LCR reached?
Discharge certificate.
LCR reached?
No.
Then LCR has to become. Call for LCR. Please take down. During the course of argument, it appears that LCR is required to be perused for determination of the instant appeal. Accordingly, department is directed to call for the LCR from the office of the learned tribunal immediately. List the matter on February 6th for further hearing.
Discharge certificate কোথায় এখন পাবো?
the department is directed to call for the LCR within that stipulated period.
আমি তো ইন্টার এক্সিবিট দিয়ে দিই
দুটো খাবার ফলে।
লেখা আছে discharge.
Okay. Today I don't have the time. I have the division.
It will be মানে on 6th February.
6th. At 2 p.m. I have several determinations.
My lord.
Okay.